Hello, my name is Robert Brill. I'm a doctoral candidate in health psychology, and this is my Fibromyalgia podcast series. Today I would like to discuss disclosing your chronic illness to your employer. The question then becomes, should I tell my employer about my fibromyalgia? There are more and more people each year diagnosed with and learning to live with fibromyalgia. This means there are more and more people working with fibro. The Americans with Disabilities Act provides guidelines for accommodations that employers are supposed to make for those working with disabilities. This is not to say that just because you have fibro, you are automatically disabled from work or that you even need an accommodation, but some people will. So the question is raised, do I tell my employer I have fibro? To me, this question is not a simple yes or no answer. My answer is, it depends. The reason it depends is because many employers will make only very slight accommodations to do so by law. And most employers won't say it, but they don't have room for employees with limitations or special needs, especially those employees who need extra breaks, longer lunches, and more sick days off or flex time. These accommodations cost employers money. So then, should I not tell my employer about my fibro? Again, not a simple yes or no. If you have no choice but to work, and your disability or limitations get in the way of your job, you may have to inform your employer because sooner or later you won't be able to hide your shortcomings. And if you miss extra work due to fibro, you're going to run out of valid excuses fast. This becomes a very complex situation. As an employee, you should know your rights, but as an employee with physical or mental job limitations, it becomes essential that you know what you can and can't do, what you should and shouldn't do, and what your employer can and can't do to you. Knowing your rights means knowing what you can get away with as a person with a disability and still keep your job. These laws are specific to each state in most cases, minus a few laws that are federally imposed. If you are in need of special or reasonable accommodations to perform your job on a sustained basis, that means on a regular basis, you may need to approach someone at work to request a special accommodation such as a special chair, a special keyboard, a work area near a bathroom, adjusted lights above you, a flexible schedule or part-time status, or so on. Besides the potential embarrassment of informing your boss that you have fibro, your whole department may soon know that something is going on. And to avoid coworkers from becoming angry at you for slacking off, taking extra breaks, or missing too much work, you may have to figure out a way to break the news to everyone in your department or working near you. Maybe you can get away with only informing your human resources department, who can make accommodations for you without the rest of your department knowing why. But at some point, your coworkers may find out one way or another, assuming that your work is impacted. If you work for a small employer, like more than half the country does, you may have to be much more open about your limitations or special needs. This is where it really depends on your relationship with your boss. If your boss likes you, values your contribution to the organization, and literally has the ability to make the accommodations, he probably will. The problem with small employers, less than 15 employees, the ones I'm talking about, is that there may not be money in the budget to make special accommodations, like purchasing expensive ergonomic office equipment or allowing you to work flex time when you feel well enough to come to work. If you work for a company that has 5 or 6 employees, for example, your contribution is likely critical, which may translate into your employer not being able to work around your health conditions. Also be aware that employers do not have to make special accommodations for disabled employees. For example, according to Title I of the ADA Act, protection falls on employers with 15 or more employees only. Further, the term undue hardship in the ADA Act means if the accommodation costs too much money, the employers don't have to make it. They can claim undue hardship and get out of having to buy something special or allow you to work flex time. ADA Title I from the ADA.gov website suggests that employers with 15 or more employees to provide qualified individuals with disabilities an equal opportunity to benefit from the full range of employment-related opportunities available to others. For example, it prohibits discrimination in recruiting, hiring, promotion, training, pay, social activities, and other privileges of employment. It restricts questions that can be asked about an applicant's disability before a job offer is made. That's before a job offer is made, nothing about afterward. And it requires that employers make reasonable accommodations to a known physical or mental limitation of otherwise qualified individuals with disabilities, unless it results in undue hardship. Religious entities, such as churches with 15 or more employees, are covered under Title I. So the choice to inform your employer that you have a disability is your own, and it comes down to a number of factors. Think your situation through and know your rights and all the laws that may apply to your situation. In the end, the decision is up to you, but be careful and really think it through and strategize your approach to your employer. Thank you.